this opinion is talking about what you need to prove in a second offense DWI. And for those of you, and the reason I picked this tonight to talk about is because there are over 15,000 DWI cases filed in Harris County alone each year. So it's a pretty prevalent crime, and I think people should, that people are charged with, and so I think that people should understand what the law is that the state actually has to prove against them. Now, this case dealt with a second offense DWI, and historically, up until this case that came out, everybody kind of viewed the fact that a prior DWI was something that the state had to prove up at punishment. The enhancement paragraph, so to speak, is what we call it around there. And that you had to prove that up at the punishment phase, not during guilt innocence. And the case went up that was appealed by the defendant, which the court ruled, nope, you can't stipulate and keep that fact away from the jury because you now have to prove it during guilt innocence because it increases your mandatory, your minimum punishment from 0 days to 30 days. And Gary, you and I were talking before the show. I mean, I'm not surprised by the ruling because federal courts have ruled that years ago that any factor that increases your punishment must be proven to a jury. And so I'm more surprised that it's taken this long for a state court of appeals to find this. I mean, to me, it was kind of a nice little loophole that defense lawyers had.
Right, it was a loophole. I mean, we've had this in other cases. You know, just take DWI example, DWI third, felony DWI. The jury at guilt innocence, the first stage of the trial, would hear that you have 2 prior DWI convictions, meaning the prosecutor had to prove up those to show why you were even in a district court, a felony court, to begin with. So, and we see it in other cases too, you know, theft thirds. You also see it in, you know, felons in possession of firearms. They've got to prove up that you have a felony on your record to make it illegal. But yeah, it didn't, I'm surprised too it hasn't taken this long.
Yeah.
I don't like the decision, obviously, but I can understand kind of the logic behind it.
Yeah.
I mean, DWI is developed over years and years and years, and it just keeps going more and more against the defendant. You know, there used a long time ago, there was if your prior was over 10 years old, they couldn't use it against you. Now it's forever. You know, you got your DWI in 1989. Well, here it comes again. You got your
DWI in 1969. Here
Correct.
It comes again.
It doesn't matter. The years don't matter. They used to at one point. Now it just gets worse. So now, you know, lawyers are going to have to deal with this in voir dire, obviously, and judges. It probably is going to be harder to get a fair jury, I would imagine.
So that's one of the questions I had about, you know, is it going to lead to more busted jury panels?
It's gonna I would think it's going to have to. I think it's going to lead to more busted jury panels, and when you finally can seat a jury, it's still, I think, going to stink. So prior to 2 days ago, when a defendant gets arraigned, an individual gets arraigned, they say, here, on this day, Joe Blow did therein commit the offense of driving while intoxicated against the peace and dignity of this state. And that's all you would hear. To which the defendant pleads not guilty. But now, as of 2 days ago, an individual will be arraigned like as follows. Here, Joe Blow did and then on such and such date commit the offense of driving while intoxicated against the peace and dignity of the state, and he's been convicted of DWI 2 years ago, to which the defendant pleads not guilty. But by the time the jurors hear he's been convicted of a DWI, this is his second one already? Are you serious? Forget this, he's guilty. And all the studies show that jurors tend to have made up their mind after opening. So you got voir dire and opening, the 1-2 punch. After that, jurors have generally made up their mind according to some studies. And so by adding this stink to the beginning, it's going to, at least in my opinion, make it very difficult to basically say, look, guys, all right, jury, client, he was convicted of a DWI 2 years ago, but this time, didn't do it. Didn't do it, all right? And so just ignore that. I think it's going to be very difficult for a defense lawyer to overcome that, or at the very least, as always, we're just going to have to get smarter, faster, stronger, more creative to attack those kind of issues.